Welcome to the breakout session here at 10 o'clock. Thank you for coming. This session is going to be understanding your rights when regulators come knocking. I'm Paul Dyke, the Regional Sales Manager for Quality Liquid Feeds. Thank you for DBA for allowing us to sponsor this session. I'm always a little bit surprised going around this state. I cover 2 states, Wisconsin, Minnesota, and people kind of ask me, who is QLF? What does Quality Liquid Feed do? I'm a little bit surprised by that. QLF it's one of the great Wisconsin stories. If you don't know, Quality Liquid Feeds is the only national liquid feed company based in Wisconsin. Actually, Dodgeville, Wisconsin is where we're based. We're a family-owned business, owned by the Berg family for over 35 years, and providing solutions to farms. Sometimes our solutions are simple liquid feeds, bringing sugar. Sometimes they're full suspensions onto the farm. Last few years, we've also kind of veered into the agronomy field. We have some unique solutions that we can bring with our ingredients to the agronomy side. Any questions on those, let me know, and we can talk a little bit more. The breakout speaker for this session is Tom Janczewski. I think I've got that right. He's a partner in the litigation practice group at Michael Best and Friedrich, and also a member of the firm's agribusiness food and beverage team. Janczewski has represented farmers and food and beverage manufacturers in matters ranging from perishable ag Commodities Act claims to EPA enforcement proceedings against concentrated animal feeding operations. Janczewski also has substantial experience in both state and federal court, handling a broad range of matters, including commercial torts, contract disputes, false advertising, trade secrets, property taxation, products liability, and insurance. In his free time, he serves as president of the Wisconsin Ag and Life Science Alumni Association and is a member of the Alpha Gamma Rho National Ag Fraternity. Please help me in welcoming Tom Janczewski.
Thanks, Paul. And these are my children, Zeke and Bart, but we'll send them away for now. True to form, I see most people have opted to sit towards the back of the room. You know, want to keep a healthy buffer zone between you and the lawyer, and that's understandable. As a lawyer, if you interacted with lawyers, you know lawyers love their disclaimers. And so before I dive into this topic, I want to give you my disclaimer, which is the subject matter today is really to help you understand the basic framework that administrative agencies operate under when they come to inspect private property. I'm not going to get into too much, although we will look at 3 examples of the way specific agencies conduct themselves. If you have a specific question about a specific agency, we'll need to connect you with a specialist that practices in that area. For example, if you have a question about OSHA inspections, I'm not a labor attorney, but I know lots of great labor attorneys that would be able to answer your more nitty-gritty type of questions. So with that disclaimer out of the way, this morning we're going to talk about administrative searches. I'd like to cover what is an administrative search, and I use the term administrative search interchangeably with an agency inspection. How do regulators gain access to private property? If a government official makes an unannounced visit to your property, do you have to let them in? And to give you a preview, the answer is, well, it depends. What is an administrative warrant? How does an agency get one? And what are your rights if the government serves one on your company? And then finally, I'd like to get into how do you train your employees to respond to an agency's request or sometimes a demand to search your premises. Now, to set the table, I'd like to first take a look at one of the most famous agency visits ever recorded on camera. And I'm, of course, talking about Ghostbusters. And
now you catch ghosts. Yeah.
all right, we have a technical difficulty here. Do we have someone that could assist with the sound?
I'm not at liberty to say. Would the storage facility be located on these premises? Yes.
Can anybody hear
Can I
that?
see the storage facility? No.
Okay. I think you got the gist of it. So there are some things that I like and some things that I don't like about Dr. Venkman's performance here. But this is what we're talking about, that agency visit to private property, often commercial property. One of the things that I liked about what Dr. Venkman did here was he knew that he had the right to say, no, I am not going to let you inspect my storage facility. One of the things that I didn't like so much is he answered a lot of questions that he didn't have to answer. And as we'll see, and if you've seen this movie and you haven't seen it, I'm going to apologize for the spoilers. The EPA agent then takes the information that Dr. Venkman gives to him. He goes back to his office and he goes to court and gets a warrant to come back and search the storage facility. And again, spoiler alert, it nearly causes the coming of Gozar and the end of all life as we know it. So, I don't want to say that if there's a government inspection, it's the end of the world. But if Ghostbusters has taught us anything, you never know. One of the things that, had you heard the audio, you would have picked up on is at no point during this interaction does the EPA agent say to Dr. Venkman what his rights are. He doesn't tell Dr. Venkman, you don't have to answer my questions. He doesn't tell Dr. Venkman, you don't have to consent to my searching of your storage facility. And that's true to life. The regulators that visit your property are not going to tell you what your rights are. I think there's this expectation that they will because we watch television procedurals where the cops always read you your rights. And that only takes place when there is an arrest. And there should never be an arrest type of situation when regulators are coming to do routine inspections of your property. So they're never going to tell you what your rights are. You have to know what your rights are, and you have to be prepared to exercise those rights under the correct circumstances. So the first question you might have is what gave Dr. Venkman the right to send the EPA officer away without conducting this inspection? And I'm going to give you a brief refresher on high school government, on your high school government class. And the source of Dr. Venkman's rights here are the Fourth Amendment to the U.S. Constitution. And the Fourth Amendment says, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue upon probable cause supported by oath or affirmation, and particularly describing the places to be searched and the persons or things to be seized. Now, there's a lot to unpack in that short paragraph. The first thing we want to acknowledge is there is a warrant requirement. The government cannot show up at your property on a whim. And I think people are often surprised when I give these types of talks to find out that that warrant requirement typically applies to every visit of a regulator to private property in the same force that it would apply to the law enforcement agents. There are some exceptions, and we'll talk about those. The second point is if you read the text of the Fourth Amendment only prohibits unreasonable warrantless searches. And courts have decided along the way that some searches, even without a warrant, can be deemed reasonable. It goes without saying, or maybe it doesn't, but businesses have Fourth Amendment rights. Otherwise, my talk would not have much utility here this morning. And the idea here is just because you engage in commerce does not mean you forfeit all of your constitutional protections. Another point is that the Fourth Amendment applies to both administrative searches as well as traditional criminal investigations. All administrative searches must be carefully limited time, place, and scope. If you go back and you read the Fourth Amendment, there's a provision here that says that the government must particularly describe the place to be searched. And what this means is the government can't come to your property with or without a warrant and say, you know, we're going to hang out here for a month, just kind of see what you're up to. Are you cool with that? The Fourth Amendment prohibits that type of conduct. And then another key point here is that investigators are not permitted to search in places that could not bear upon the compliance with the regulations that form the basis for the warrant. And to quote our federal appeals court, if you are looking for an adult elephant, searching for it in a chest of drawers is not reasonable. So the regulators can only look in places that might bear upon the regulations they're enforcing. Okay. As I've already alluded to, the Fourth Amendment and your rights under the Fourth Amendment apply both to traditional criminal searches, which are typically are based upon probable cause that a crime has been committed. Now, in the administrative context, the government doesn't need to have probable cause that a crime has been committed or that you are violating a regulation, although that can form the basis of a warrant. Another way that the government gains access to private property is to show that it has an administrative scheme that provides for routine inspections of private property, and today is your lucky day. Another thing about administrative searches is every search is going to be a little bit different. Sometimes the agencies just want to see documents. Sometimes it may want to visually inspect your plant. Other times it may want to take swabs and samples. It depends on the agency and what the agency's objectives are and what regulations the agency is enforcing. Federal, state, and local agencies all may perform certain administrative searches. And today we're mainly going to focus on federal regulators, but these same principles apply to state and local agencies as well. So, how are these searches initiated? As I've already alluded to, one way is based upon specific evidence of an existing regulatory violation. And one of the things here is that the evidence must be specific. The government cannot allege in broad strokes, we think Smith Dairy is violating certain regulations. There has to be some specificity, some meat on the bones forming the basis of that belief. And a couple ways that agencies might get that specific evidence could be a tip. A concerned citizen, a disgruntled employee calls up the agency and says, hey, I think Smith Dairy is violating these regulations, and I think you should go out and take a look. Another way is that the agency might be able to do its own investigation that does not quite touch upon the Fourth Amendment and gather some information and then use that as a basis for further inquiry. A good example of that would be the aerial flyovers that EPA likes to conduct. The Supreme Court has said that aerial flyovers is not a search because people don't have a reasonable expectation that planes are not going to fly over their property and look down. And then the second way, again, there's two ways, either having the specific evidence or following a regulatory scheme for routine inspections, is on the basis of a general administrative plan for the enforcement of the act, whatever act that may be. In this case, it was OSHA, derived from neutral sources such as, for example, dispersion of employees in various types of industries across a given area and the desired frequency of the searches in any of the lesser divisions of the area. So what does this mean? It means that if the government is going to inspect your property, it must follow some fair, neutral criteria. Administrative inspections are not intended to be a pretext for the government to come and harass or single out particular companies. Everybody is treated the same. And again, the regulations determine when it's your lucky day for your visit of your friendly regulator. So with all of that said, how does government actually obtain access to private property in light of the Fourth Amendment? Well, when we read the Fourth Amendment, we know there's a warrant requirement. So one of the ways that government can get access to your property is to go to court and get a warrant. Just like a criminal warrant, an agency has to go to court to get the warrant, and they have to show probable cause. And as I mentioned, probable cause can be either an existing regulatory violation or that the agency is fulfilling its obligations and performing routine inspections, and it is your turn for your routine inspection. And then finally, even if an agency has a warrant, there may be an opportunity to have your lawyer go to court to do what's called quash a warrant, which is exactly what it sounds like. And some of the bases to quash a warrant might be the agency is coming to perform an inspection and doesn't have statutory authority to do what it wants to do. Or, the agency has a warrant that says it does get to hang out for a month and just, find out what I'm up to. And that would not be limited in time, scope, or time, place, or scope, and that would be, therefore, constitutionally deficient, and the court could throw the warrant out, and then you'd be free to make the inspectors leave. So having said all of that, almost no searches are performed pursuant to a warrant. Instead, almost all searches are performed by consent. And if you have inspectors that come to your property, chances are, whether you realize it or not, you have been consenting to those searches. And a lot of people are surprised to hear that they don't actually have to let the inspectors onto their property without their consent. Now, there may be very good reasons to consent to particular inspections, but know that you are consenting to those inspections. I sometimes liken this to those old black and white monster movies where, Count Dracula's at the door, but he can't come in unless you invite him in. And this is sort of similar. The regulators can't come onto your property without a warrant unless you invite them in. And again, there's exceptions, and we'll talk about those. As I mentioned, there may be some very good reasons why you want to consent to the search. If it's a frequent a regulator that you want to maintain some good, cordial professional relationships with, you may want to make sure that you keep that relationship strong and not be, overly a pain in the butt. And there may be other reasons, but you should discuss these with your lawyer when you're talking about, should I let EPA on my property to conduct a search? That's a conversation you should definitely have. One of the risks of a consent search as opposed to a search warrant is a search warrant is a written document. And the Fourth Amendment requires that it specify what are they looking for. In a consent search, it might be a little bit more fluid and fly by the seat of their pants. The inspectors may come and explain to you, we want to look at these two things. And then during the course of the inspection, they may say, well, you know what? While we're here, would you mind if we go look at this other production line? And that's very common. And so there is a risk that you think you're getting into one thing, but as the inspection evolves, it's a much broader inspection that you had originally anticipated. Now, keep in mind, when you do consent to a search, you are waiving important constitutional rights. In the commercial setting, you wouldn't want to sign a contract unless you at least thought you understood what your rights and obligations are under the contract. And in a way, when you give consent for the government to come and search your property, it's almost like an oral contract that you are waiving your constitutional protections against unreasonable searches and seizures. And that's fine, but you must firmly understand exactly what the rights and what you're waiving before you do so. And again, this is a very self-serving comment, but I think you should have the assistance of counsel before you make those types of decisions. Among other things, you're going to want to know what exactly are the regulations that the inspectors are enforcing, and you're going to absolutely want to know what are the potential penalties I face if the government finds something deficient in my premises. So, who has the authority to grant consent for a business? It's not just the business owner. It's not just the high-ranking managers. It's anyone within your organization that the investigators reasonably believe have the authority to grant the permission. And so, if the court is looking at the question of were the inspectors lawfully on the property, they're going to try to put themselves in the shoes of that investigator in the heat of the moment to determine whether it was reasonable for that investigator to believe whatever the person that gave them permission, whatever the scope of their authority actually was. Another key point here is that the consenting party can revoke consent at any time, and the search must stop. So if you initially consent to an inspection, the inspectors say we want to look at these two little things and then we'll leave, and it's taking them longer than you're comfortable with, or for whatever reason you begin to feel uncomfortable with what the inspectors are doing, you have the right to say, I revoke my consent, and I would like you to leave. And the inspectors, unless they have a warrant, are required to then leave your property. So if you initially consent, all is not lost. You can always revoke that consent. So we have a warrant. We have the permission or consent of the property owner. And then we have this other exception for what are called pervasively regulated industries. I think in today's day and age, the term pervasively regulated industry is more of a term of art, because I suspect that just about every industry today feels like they are pervasively regulated. Unfortunately, the courts have not quite gone so far as to say, if you're engaged in commerce, you're pervasively regulated and you have no Fourth Amendment rights. So far, the U.S. Supreme Court has recognized 4 industries that are pervasively regulated: alcohol, firearms, strip mining, and junkyards. I'm assuming nobody here is engaged in those activities. However, some of the lower courts have said that the FDA, when it is inspecting food and drug companies, are acting upon pervasively regulated industries, and provided that they have certain procedural protections in place, they do not necessarily need a search warrant. And I will also say, for those dairy farmers within the state of Wisconsin, there's one case from 20 years ago in the state appeals court that said DATCAP, when it is inspecting dairies, also can conduct warrantless searches. Now, I don't know whether that would hold up if that were challenged either to the Wisconsin Supreme Court or in the federal system, but there is the existing law right now would be that for DATCAP inspections of dairies, they do not necessarily need a warrant. Before I leave this topic, one important point is, even if you are in a pervasively regulated industry, it's only that specific agency that would have the right to come in and search without a warrant. It would only be FDA. If you are a food and drug company, it's only FDA that might have the authority to do a warrantless search. But if OSHA wants to do a search, OSHA would still need the warrant or your permission. So, the agency playbook here. It typically goes 2 ways. I've told you that most searches aren't conducted with a search warrant. So what the agencies will typically do is first they'll ask for permission, or maybe not always ask for permission. They may assume permission unless you tell them to go away. And then if consent is denied, the agency then has a decision to make. Do they want to go to court and get a warrant and then show up on a surprise visit in the future, or do they want to negotiate with the property owner a time that's suitable for both parties to conduct the follow-up investigation? And so what I'd like to do now is to walk through some agency inspection manuals and to learn maybe a little bit how the agencies are instructing their own folks how to interact with the regulator. And most of these things are online. And if you're interested in, knowing the playbook and the play-by-play of how these inspections go down, it's all available for you. And I think it's a good idea if you frequently encounter inspectors from various agencies to know, exactly what is the playbook. So that way, when they show up, there's no surprises. You know exactly how everything is going to proceed. So the first one we'll look at here is EPA Clean Water Act enforcement. This is actually not an inspection. I think this is a remediation from Hurricane Katrina. And it looks like the remediation efforts involve using hotel bath towels to sop up the problem. And I don't know if that's best practice, but anyways, I found that surprising. So the first thing that EPA tells us is that when the inspectors arrive at the facility, and the facility inspection should occur during normal working hours, the facility owner or agent in charge should be located as soon as the inspector arrives in the premises. And that's good. Consent to inspect the premises must be given by the owner or the operator at the time of the inspection. And this is great. It's good that EPA is recognizing that the owner of the premises has to give its consent. But then it takes a dark turn as the passage continues, because what the EPA considers to be voluntary consent may not be what a normal person would think is voluntary consent. EPA says, as long as the inspector is allowed to offer, entry is considered voluntary and consensual, unless the inspector is expressly told to leave the premises. Express consent is not necessary. Absence of an express denial constitutes consent. So your silence means that you want the EPA there. Unlike Count Dracula, who may need that express permission, come on in my house, EPA says, as long as you don't say, go away, we're going to presume that you want us to be here today. Here's another good one. The receptiveness of facility officials toward inspectors is likely to vary among facilities. Most inspections will proceed without difficulty. And one of the reasons most inspections will proceed without difficulty is a lot of people are uncomfortable with knowing whether or not they have the right to refuse entry. And so, of course, they let inspectors in. And it continues. In other cases, officials may be reluctant to give entry consent because of misunderstood responsibilities, inconvenience to a firm's schedule, or other reasons that may be overcome by diplomacy and discussion. So if you tell the inspector, no, I don't want you to inspect my property, they're going to try to cajole you and use diplomatic means to get you to allow them on the property. The part I like here is that if the reluctance is based upon some sort of misunderstanding. And here, this quote is not in the inspection manual, obviously, but this is a quote from an EPA water enforcement official from a couple years ago. and I'll read this to you. You tell me if the property owner is misunderstanding the situation. We are going to knock on your door, and you aren't going to know we are coming. We like to go out during wet weather. A lot of farmers say we came out during the worst conditions. It is planned. We want to see your facility under the worst conditions. So if you have some reluctance of letting regulators onto your property and letting EPA onto your property, I don't think it's because you misunderstand the situation. I think reluctance is absolutely required. It may mean that you do consent ultimately, hopefully after consulting with your lawyer, but it should be a reluctant consent, to say the least. One of the things to think about as we read this quote is EPA doesn't care if you're in compliance 364 days out of the year. they want to select that one day out of the year where they think you may be vulnerable to an inspection, and that's the day they want to select to go and visit your property. So as you're thinking about, is it wise to consent? Understand that EPA thinks it's not wise for you to consent. EPA thinks they're going to find a regulatory violation on this particular day if you consent to that search. When the quarterback goes up to the line and sees an all-out blitz coming and knows that the package he has in place will not hold up, a common approach is to take a timeout, to regroup, and to go from there. So, as you're deciding, should I consent, should I not consent, you always have the option of calling that timeout, having an opportunity to discuss the situation with your lawyer, understand what the regulatory requirements on you are, and try to make sure that if there's any non-compliance that you currently have, that you get those all shored up in short order. Because ultimately, that's the goal of these regulations, is to make sure everyone is in compliance. The goal of the regulations isn't to ring people up for large penalties. And here, I'm not going to read this whole passage. The gist here is this is an acknowledgement that EPA usually doesn't obtain warrants, and it's actually a special situation where EPA would go to court and get a warrant prior to an inspection. So the second one we'll look at here is OSHA. Here too, OSHA recognizes, well, in this case, OSHA, the OSHA manual specifically says we're not going to give any advance notice before we appear. All of our inspections are going to be, have the element of surprise under statute. And here, OSHA actually specifically recognizes in its manual that property owners do have a right to refuse entry, and OSHA would have to go and get a warrant if it wants to inspect that property. One of my colleagues in our labor group likes to say that this is sort of a one-time thing. You get to pull that lever once. So make it good, because the first time you refuse the OSHA inspectors from coming onto your property, and they have to go to court to get a warrant, from that day forward, they're probably just going to go to court, get the warrant, and then show up for a surprise visit. And when the agency shows up with a warrant, you have really no legal way to resist the search other than going to court and trying to quash the warrant if there's a basis to do so. Okay, the inspector locates the owner representative. Okay, that's all good. And here too, after acknowledging that I'm getting a 5-minute warning, so I'm going to start to speed up here. Here, OSHA says that even though we acknowledge we need consent, what they're going to do is they're going to wait around for an hour, and if the correct person doesn't show up, they're just going to go forward with the search anyhow. Here, OSHA says on multi-employer worksite, valid consent can be granted by the owner or another employee with employees at the worksite for site entry. So if you have contractors on your property, they may be able to give consent to search your property if OSHA makes a visit. FDA, I'll touch briefly. As I mentioned, FDA, when regulating food and drug companies, the lower courts have said they do not need a warrant, but instead they do have some procedural protections. They have what's called an FDA, in the 482, and it looks something like this. Actually, it looks exactly like this. So when FDA shows up at your property, they may not have a warrant. They'll have this Form 482. And FDA recognizes that some people may still resist the search, and the FDA manual notes that a warrant for inspection is not necessary unless refusal or partial refusal is encountered or anticipated. And then there's the specter of, if you deny entry on the 482, FDA may try to use this heavy hammer of bringing these significant sanctions against you, including criminal provisions of the Food, Drug, and Cosmetic Act. Okay. So, and this is really all culminating up to the rousing conclusion here. So what do you do on the day of an unannounced visit? Well, if the agents do not have a warrant or a substitute like the FDA 482, immediately contact your counsel and then follow counsel's instructions. Again, this is self-serving, but you're really going to want to have a dialogue with your lawyer before you decide whether or not to let them in. There's no one-size-fits-all solutions to these encounters. Every encounter is going to be a little bit different. The agencies are enforcing different regulations, and some of the regulations have a really, really heavy hammer hanging over your head if they find a violation. So you're going to want to have this discussion with your lawyer. And then second, you're going to want to, again, self-serving comment, follow your lawyer's advice. So in some cases, your lawyer will say, don't let the inspectors on your property. And there's lots of reasons to refuse letting the inspectors on your property. It's not any sort of admission that you have something to hide, but you may be distracted by the day-to-day operations of your visit. It may just, it could be just a really bad day to have inspectors going through your property when that inspection really needs your undivided, 100% undivided attention. And then secondly, for certain inspections like EPA, you may need to be prepared so that way you're ready to go side by side with the inspectors and take your own samples. So that way you can do your own testing just in case something pops up on EPA's tests and you can confirm whether they did the test correctly. Again, I would advise do not consent to the search unless and until you have the green light from counsel, or at least until you feel absolutely confident you know what the regulations that the inspectors are enforcing are, what the penalties are, what the inspectors are going to look at, how long it's going to take, etc. Now, if the agents have a warrant, now your options are much more limited. You have to let the agents on your property to conduct their inspection. You should still contact counsel and have them appear as soon as possible. And you can ask the agents, could you please delay the search for a period of time to allow my lawyer to show up? But the agents are under no obligation to grant that request. You're going to want to study the warrant very carefully and make sure you understand the scope of the search. And then you're going to want to keep a very close eye on the inspectors, take really good notes, and make sure that the inspectors aren't going outside the letter of what the search warrant allows them to search. During the course of their search, they may, again say, since we're here, here we have this warrant, since we're here, would you mind if we also go look at this other part of your property? You can say no to that. They are only permitted to search what's in the letter of the warrant. On the day after the inspectors conclude their inspection, they may ask you to sign an affidavit. You do not have to sign anything that they present to you. And, for the lay people here, an affidavit is essentially sworn testimony. It's as if you were in court with your hand on the Bible saying, I swear to tell the truth. When you sign an affidavit, that's what you are doing. And lying on an affidavit is punishable by perjury just as testimony in court would be. So it's a very serious thing. So you do not have to sign the affidavit, and I would recommend not signing the affidavit. Wait for it, unless your lawyer says it's okay. And here's really the key. You shouldn't wait until you hear that knock, knock, knock to start planning for government officials visiting your property. You should start to plan, maybe not today, you have a lot more fun things and important things to do today, but in the near future, sit down with your attorneys and map out how do we respond to an agency inspection. And I would also say that if you anticipate, for example, an EPA inspection, you're going to want to talk to an environmental lawyer. If you anticipate OSHA inspections, talk to your labor lawyer. I think the regulations governing these matters are very complex and technical, and you're unlikely to get good enough advice from a generalist. You're going to want to know how to get a hold of your specialist on short notice, have a backup, and I recommend reviewing the agency's inspection manual. As far as how do you train your employees, I think you're going to want to select a single point of contact at each facility for the initial discussions with the agents, and make sure that everybody who's not that person knows that they are not that person and they cannot give consent to a search. You may want to have different people for different regulatory agents. For OSHA, you may want to have your chief safety officer, for example, and you may want to have different folks for the different agencies. And here's a key point, too. You don't have to select the owner or the most highest ranking person to be that designee, although the owner certainly would have the authority to grant consent. You don't have to select them as that person to have that initial dialogue. And in some cases, it may be wise to have someone other than the owner or management. You've certainly heard the stories of people in high management maybe having a short fuse or maybe a bit of a hothead, and that's not necessarily the person you want engaging in these initial dialogues with the inspectors. You're going to want to have someone who maybe reminds me of my grandmother and grandfather, someone who is very even-tempered, polite to a fault, but not a pushover, someone that's not going to get flustered, and someone that's going to stand their ground. You're going to want to make sure that all of your employees know that while inspectors are on the premises, they do not have to answer any questions or speak to the investigators. What you can't do is you can't try to discourage them from cooperating with the government, but you can let them know they have no obligation to speak to the inspectors, and in fact, we have this designee whose job it is, among other things, is to answer all of the questions that the inspectors have, but you can't try to discourage the investigation. Some commenters have suggested that on the day of an inspection, it's okay to let non-essential workers home. And this might be an option, but talk to a lawyer before you adopt this policy. And then lastly, make sure you keep all your documents organized. You don't want to have, for example, the smoking gun memo from your lawyer saying, I think you're violating a bunch of OSHA regulations right in the file where you keep all of the documents where OSHA is going to want to review. So make sure you keep everything organized. So if someone's looking for your documents, you have your file, you hand it over, and you know it's only what the agency is going to need. I think I've gone a little bit over, and thank you everyone for listening this morning, and enjoy the rest of the seminar.
Maybe time for one question. Got maybe one?
Yeah.
Sure.
You used a word I haven't seen used before. Exigent.
Oh, exigent?
What does that mean?
Exigent.
Can you repeat the question?
He said that I used a word in the presentation, exigent. Exigent is really something that applies more in the criminal context. It's the fleeing felon situation. If you're watching Cops or some reality show and you see the cops chasing someone through someone's backyard, anything that the cops see in that situation, the emergency situation, that is not considered a search, or it's an exception to the Fourth Amendment. Does that make sense? It's an emergency situation.
All right, we're going to keep rolling. Thank you, Tom. If we can give a hand for Tom, thank you for his time. Now, the important part is you got to choose where you're going to go next. You could stay here for another session and listen to this again. That's one option. Section B is the evolving relationship between veterinarians and farmers. Section C, fan testing at the best lab, importance of ventilation testing for the dairy industry. Section D, high immune response technology and breeding selection. Or meeting rooms KLM OPQ. They got a lot of rooms. Angel funding and investment opportunity and a way to stimulate development of new solutions and technology for Wisconsin dairy farmers. That's with Kent Weigel. So thank you for coming, and you're off to your next session. You got about 5 minutes or so. Thanks. That was good. That's always tough because I know you're, I mean, probably, it's all, I don't want to cut you off, but
Yeah, no, I understand.